See, here's part of the process of the problems with, you know, underlyings. It's kind of like when you create a kangaroo court and you intentionally alter the record so that you can hook up deals for a particular period of time. And then you do things like intentionally misrepresent facts of the matter. I'm looking again at this website that's presumably connected to this case associated with a disbarment proceeding regarding a lawyer in Texas who happens to have the same last name as not only a member of the board of directors for Halliburton, but also the same last name as a person that replaced Benjamin Netanyahu as the prime minister of Israel. That happened within the last couple of months, right? There's Bennett replacing Netanyahu. And this guy, Bennett, has now, it seems, 3 times changed, materially altered the official record of his proceeding. First of all, the only acknowledgement I can find right now in terms of the official court records associated with his case identify a male judge. The original proceeding was specifically regarding a woman who was the judge in the original opinion, and the transcript, at least in 2015, 2016, on its way to 2017, revealed that several things had happened. Among the things that happened were her discussion about the turning off of cell phones in the courtroom, and then during a point in time when the opposing attorney was attempting to list his relief that was being sought or what he was seeking in terms of the judgment in regards to the case, and he provided details of what that would be. There was a text message that came to Bennett. His cell phone apparently was not turned off. And in the course of that cell phone message coming to him, the judge remarked on cell phone message coming into the courtroom. Bennett said something, but then after that, she recounted what she understood to be the list of relief that was being sought. And there was one very, very important key piece of relief that had previously been requested that was not in her recounting. And the opposing attorney did not correct her. Now, I've already gone on the record in other manners, including in terms of YouTube videos, and also in what would have been the actual response to my motion for a new trial. Motion for leave to file a motion for a new trial that I submitted here in Dallas, because the court transcript record, while this was being appealed through the Supreme Court of Texas, in a case number that referred itself to a report number I had submitted with the state auditor's office of Texas, by the way, that also was a carryover from a case number in this specific case that had the last couple of metrics of my social security number, which is also associated with an executive order that goes back to the time when I was a minor getting my driver's license. And these factors all were part of the challenge I was attempting to issue or to make through the court. In the altered transcript, there is evidence that is presented as fact, that is actually a contrivance, that misrepresents the original transcript as including the judge discussing matters related to permitting people to use their cell phone. One of the things specifically discussed was how she uses her cell phone to keep time. She was identified as using her cell phone to keep time. And then 2 more instances occurred when the members of the assembly, the opposing attorney and the supporting attorney, were using their cell phone in the courtroom. And in one of those instances, while they were doing stuff with their cell phones, she agreed to leave her own courtroom and leave them in the courtroom to do things that they were doing with those cell phones. This was recounted on the transcript that was available in the summer of 2019. Now, I've taken that transcript into evidence. I have the PDF version of what was presented on the website, the one I'm looking at right now, in my evidence, along with my notes and my notations and my specific pieces of information associated with the fraud involving the original presentation of the transcript that was presented to me as fact, and the second transcript that I saw during the summer of 2019 that was available at least until October of 2019 on the website. And then in 2020, I checked back this same website, and that same transcript was available at that time. Now there's something different, and there is alleged to be some sort of record regarding the closing arguments ruling of the court for another time frame. The same case number, the original case number, that includes, by the way, the last 3 numbers of my social security number, and discusses another presiding judge, a male. But in the course of this, what do we have? What does it say? So I guess I'm going to get my phone That's the way I keep time. Well, unfortunately, what is being reflected here as the court saying that is not what was presented originally. Originally, the representative of the court was not this Craig Smith. The representative of the court was Carmen Kelsey. Carmen Kelsey was in another transcript saying pretty much the exact. I have the written records of what the official transcript phraseology was, but that's what she did. Am I supposed to believe there were two separate proceedings with two separate judges that I'm pretty certain would have very different demographic experience indicators? And that this male judge is what? Providing confirmation that a judge using a cell phone in their own court is one matter, but permitting for other people to use their cell phones in the court is supported by that judge? Well, see, here's the thing. There's no other mention of cell phone usage in the same way there was in the other transcript. See, in the other transcript, not only was she using her own cell phone to keep time, but other people were in her court. And at one point, somebody received a text message. Bennett received a text message, and he said, "Oh, I'm sorry about this." And she's like, "Oh, don't worry. We got to make allowances. I understand. Take your time. Take as much time as you need." The transcript reflected her saying this while she was presiding over the case in 2019. Whereas in 2016, the understanding was through the transcript that he was engaged in breaking a formal rule of the court in her court. And that the timing and the context of him receiving a text message was suspect. And not only was it suspect, but it interfered with the actual proceeding itself. So all of the other considerations about all of the anger and all of the derision that was heaped upon her, presumably because of all of the offenses she committed, including ones that I myself identified her as in commission of, were later available for recontextualization by virtue of the fact that the court willfully and intentionally permitted a misrepresentation of the official court record to be presented as part of the appeal. I did what I could through the Supreme Court in the summer of 2019. I also did what I could through the District Court in the autumn of 2019. I believe this specific case is actually being used in acts of terrorism. I believe it. And not only do I believe it's being used in acts of terrorism, but I believe that every so-called lawyer that's a friend of the court has either plagiarized themselves or has engaged themselves in providing material support to those acts of terrorism. This not only challenges the credibility of the bar overall, but it also does harm to anybody that was seeking representation before the law by any of those people that willfully agreed to co-conspire. Insofar as me, for instance, trying to represent myself pro se, has been presented with the kinds of obstacles and perils that actually come with not being acknowledged as a member of the bar, not being appropriately licensed, which also means bonded and insured, and without being given the kinds of protections, including the privileges of immunity that would be given to people that are practicing law, including people that are in the role of a criminal prosecutor. I know what it's like to have my own situation and those things that are associated with me put into a particular kind of peril by virtue of trying to uphold the law or trying to advance the cause of my own rights, including in restitution for wrongs visited upon me. And how much more difficult it becomes when people that are presumably professionals are allowed to engage in not only flagrantly illegal activity, but reckless and defamatory activity that, by the way, has a fiduciary connection. The financial and economic safety of the people of Texas is compromised when members of the law are allowed to get away with representing this as fact and as if their performance and the way they're handling it is a representative of the people. That it's reflective of the people of the state and what we would do if we were actually in a position to be appropriately represented. This is an abuse of power. There's nothing legitimate about this. Now, the last time I checked the transcripts, there was a mention of this particular person, but the times and the dates have been altered. And this, I would not accept this as a legitimate transcript. By the way, where is the original transcript mentioning the original judge? Where is the original transcript mentioning the original judge? Because what it sounds like is exactly what you did with my cases. You had some woman that was identifiable as a woman of color that was put in the primary initial role and engaging in a process that was actually, by the letter of the law, illegal, and doing things she was actually not authorized to do. And then, after a certain amount of time had transpired, and all of these illegal deals had been set up, as opposed to actually acknowledging the merits of my case, and I was slandered because the alleged orders and opinions and judgments that were issued in my case materially misrepresented the facts of the case, including accusing me of bad faith when that was not the situation, and including accusing me of not presenting within the appropriate jurisdiction because they put themselves in the position of usurping jurisdiction. Then what this does now is reflect on the men that ended up backing up those women who were in performance of inappropriate legal action. Look like they're getting support in regards to a co-conspiracy with this case as well, where now a man is being presented as backing up the actions that were questionable about the judge's behavior to begin with, that ended up getting inverted. Because there could be arguments that what Judge Cormac Kelsey did was unprofessional in some regards. And I know that I went on the record as saying that things she did were questionable in a particular context. But after an appeal, where that's actually have been appropriately appealed with the official record at the time, and in consideration of facts of the case that were revealed as time went on, including obstruction, including securities fraud, including illegal internment of people, intimidation of witnesses, tampering with documents, all kinds of other actual crimes, criminal matters, not civil matters, and not contract disputes, except for a contract to commit to a criminal conspiracy. If the facts of the case had been allowed to be presented as part of a legitimate proceeding without altering the records in order to create a simulation or something that does not actually have legal standing, then she may well have been vindicated. But instead, what was allowed to happen was a process of automating appearances of particular racial typecasting in flagrant disregard for actual administration of justice, without actually getting to the substantive matters of concern, which were a variety of different matters that now have no context because the official record of the original proceeding has been altered. So now we're in this situation. Where's the transcript, the original transcript, at least what I was told and understood and have no other context for understanding except for plausible deniability, i.e., the transcript I saw in 2016 could well itself have been an altered transcript from what the actual original transcript was, right? That I saw a fraud too, and I evaluated it based upon seeing the fraud. But now this is the second time there has been a fraudulent misrepresentation of the facts of this case, including the behavior and the constitution of the person that's in the role of the judge. So I don't want to hear another fucking current about how anything connected to my life or my cases has anything to do with Bennett. Anything at all. You guys allowed for this complete sham process to get this far. We're talking very, very, very substantial harms to people in multiple countries around the world. It behooves you to deal effectively with this right now. Why is this allowed to be online? Why is this allowed to be presented online in a website that also represents itself as bearing these documents that would be associated as being professional work products, as well as what would be legally admissible in a legal proceeding? And other things are not, including the original transcript from this trial.